Good morning everyone. Myself Dr. T. Balaji, Assistant Professor, Department of International Law and Constitution Law, working at Chennai Dr. Ambedkar Government Law College, Patrai Perumbudur, Tiruvallur, Tamil Nadu. I am a participant of online refresher course on law organized from 6/9/2021 to 19/9/2021 by UGC HRDC, Gujarat University, Ahmedabad. I am going to deliver my presentation on Article 12 of Indian Constitution. Why I choose this topic in Article 12 of Indian Constitution is very unique and placed in a very unique place. If we think, we all know that how the Constitution is important. In that Constitution, how the Part 3 is important. We know that it is a fundamental rights. In that fundamental rights, we are talking about Article 32, we are talking about 226, everything. But the fundamental rights in that Article 12 to Article 36, really it have to talks about the rights only. Yes, but our constitutional framers put Article 12 and 13 in the Part 3. Article 12 says what is state, and then Article 13 states what is law, and then only Article 14 right to equality and then freedom. Like that it goes on. So we have to think, we have to teach our student why in this important part of 3 our framers put Article 12 and 13. We have to teach the students, yes. Article 12 says what is state. Only a state can guarantee the fundamental rights, and a state only can violate the fundamental rights. Not in private entity, not in private sector, not an individual person. So it is a important topic that we have to teach our student why Article 12 is important. Sorry. And then like that Article 13, it says what is law. All that thing is not a law. For a law we can say jurisprudential definition, like law is nothing but a command of sovereign or piece of paper from a legislature, whatever we can define. But Article 13 says what is law. Order, bylaw, ordinance, like that it goes on. So Article 12 teaches what is state, who is ruling us, who is violating our fundamental rights, who is guarantee our fundamental rights. That Article 12 is very important. And that too, in this 21st century, after the LPG era, liberalization, globalization and privatization we are talking about, in this era, this concept of state is now vanishing. There are a lot of case law shows that once upon a time all the sectors in the hands of government, state, but now it's reducing. So that in that situation, it is a teacher's role to make our student understand that what is state, what are all the things comes under the state, then only a student can understand, or a future advocate can defend their clients. Yes, our fundamental rights is violated by the state, by that authority. It may be local authority, it may be in a other authority. We'll see that in some of PowerPoint. We will see that. Okay, so it is a very important topic. On that topic I am going to discuss this. I'll just share my screen and then we'll go on. Yes. Article 12 Constitution of India. Yes, Article 12 Constitution of India, the verbatim term, just I'll read very quickly. Definition in this part: unless the context otherwise requires, the state include the government, and the Parliament of India, the government and the legislature of each state, and all local or other authority within the territory of India are under the control of government of India, right? We can classify it in the five ingredient. I'll come it later. This definition is an inclusive definition, not an exhaustive one. Exhaustive one, this is what this. We cannot put anything into that. That is we call this exhaustive one. But it is an inclusive definition. We can add anything like that. It goes on. Okay. So the five ingredient I told you. First one is a central government and state governments. Central government and then parliament, state government and state legislature. Two, all local authorities is 3, other authorities is 4, and then fifth one within the territory of India and under the control of India. First, I'll go from back, that is within the territory of India. We know that India is territorially we are defined from Kashmir to Kanyakumari and this side to this side. We are very defined and territory. We have a defined territory. Within this territory of India and then under the control of India. What is meant by under the control of India? We can say that is embassies. Embassies overseas, in the foreign countries we have our Indian embassies. That embassies also will come under this Article 12. And then the second part, it is a flag state. We'll call in international law, we call it as a flag state. We have a ship which have the Indian flag floating in the high seas. We call that ship also a flagship. So that is also comes under the control of India, under the control of India. Okay. So within the territory of India, under the control of India is we know. And then first 2 point also, it's very simple. It is central government and then parliament. What are all the central government and then parliament is it's a state, and the state government and state legislature. Each state, it may be Tamil Nadu, it may be Andhra, it may be Gujarat, or it may be the Delhi. The state and the legislative is a state. Okay, no dispute. And the third point, local authority and other authority. In the constitution, nowhere we can find the definition for local authority. So we can get an help from the General Class Act. I'll come to yes, the General Class Act. In General Class Act, Section 3, subsection 31 of General Class Act defines local authority. Local authority is nothing but municipalities, district boards, panchayat, improvement trust, mining settlement boards. Yes, this and all comes under the local authority. It says Section 3, subclass 31 of the General Class Act. So first 2, central government and then parliament, state government and legislature, local authority. Local authority nowhere in the constitution, but we can get that help from the General Class Act. So that now we know the 3. And then municipality, municipal corporation is a local authority. In the Rashid Khan case, it has been decided. And then in the Ajay Singh case, village panchayat is a local authority. This and all, there are a lot of decided cases. I'm going to concentrate on other authorities. So come to the next slide. Union of India versus R.C. Jain, it has been some of the guidelines has been followed. That is having a separate legal entity existence, not be a mere government agency, but must be a legally and independent entity, function in a defined area. Like there are some guidelines to decide what is local authority. But the issue lies on other authorities. For other authority, there is no definition in the Constitution. The same time, there is no definition in the General Class Act also. There is the Rescuer General Class Act. Here, the Rescuer also failed. There is no definition for other authority. Now, the ball in the court of Judiciary. So it is a duty to Judiciary to decide what is other authority. For that, we have a doctrine called ejusdem generis. Ejusdem generis is nothing but if a general word followed by a specific word, then the specific word should be interpreted in the light of general word. It is very simple. Yes, if it is a general word followed by a specific word, then the general word should be interpreted in the light of specific word. Just apply the ejusdem generis in Article 12. It says central government and then parliament, state government and then legislature, local authority and other authority. Here the other authority is a general word. Other authority is a general word where we can interpret. But government, legislature, parliament, local authority, everything is a specific word. They have some specific function they have. Okay, so keep it in the mind. We'll go to the case law. University of Madras, Shantabai. In this case, the court said that the above three, that is government and parliament, government and state legislature, local authority, are the rule-making authority. They are governing bodies. They are making law for a society. But the Madras University is an educational institution. How can we add an educational institution into the lawmaking body? So that we are rejecting Madras University as a state. So if I explain that fact and all, it takes time. So I'm short. I'm telling very short. So in that Madras University, this is Shantabai. The Shantabais were denied for us admission in the college. So that notification was challenged. In that case, court said that the above three, using that ejusdem generis, a general word followed by a specific word, a general word should be interpreted in the light of specific word, so that above three are lawmaking authorities, but Madras University is not a lawmaking authority, they are educational board, so we are rejecting, like Madras University case was rejected. And then in the subsequent case, the Electricity Board Rajasthan versus SEB Mohanlal, authorities created by the constitution or statute on whom powers are conferred by law will be considered as a law. Like that, it has been decided. Yes. Then Madras, just think about the Madras University, Electricity Board, some of the institution or industry which came to the force by the force of law. For Madras University, we have the Madras University Act in 1890s. So like that, Electricity Board, all this kind of things which have the government sanction or with the authority of the government, if this kind of institutions came into the force, then it once again you may have a doubt, like how can ejusdem generis can be fixed. In this Rajasthan Electricity Board, they have fixed ejusdem generis, like the above three are working for the welfare of the citizens. Government and parliament, government and legislature, local authority working for a welfare of the individual. Like that, Madras University, Electricity Board, ONGC, LIC, whatever it comes in subsequent cases, everything is working for the welfare of the citizen. On that basis, it has been decided by the judiciary that if a private entity or any industry came to the force or get the authority of law, they will be put it under the other authorities. Like Sukhdev Singh with Bhagat Ram Sardar Singh, ONGC, LIC, IFC, everything have a act. ONGC Act 1959, LIC Life Insurance Corporation Act 1956, Indian Food Corporation Act 1948. Like that, with the authority of law, if there is something existence, corporations are existing, then that will be considered as a other authority. Okay, so in that we have some of the point, that is, if the entire share capital of the corporation is held by the government, entire share capital, where the financial assistant of state is so much to meet almost the entire expenditure, whether the corporation enjoys monopoly. In Tamil Nadu we can say example like the Tasma selling the wine, alcohol, it is a monopoly of the government. Existence of deep and pervasive state control. If the function of the corporation are of public importance, if the department of government is transferred to the corporation, like transport department in government, we can in Tamil Nadu government I can say example, it's in transport department that was transferred as a Tamil Nadu State Transport Corporation, like that it is a transferred corporation. So what we have to keep it in mind, not only central government or parliament, not only the government of states and then legislature and then the local authority under other authority, if the industry or if the corporation or if some other entities which is falls under this 6 points, they also will be called as a state. If they are violating our fundamental rights, we can straight away approach the Supreme Court by the way of Article 32. While ending this concept, I couldn't finish my talk without touching judiciary under Article 12. Yes, judiciary. Judiciary, we know that it is not Supreme Court. It is a Supreme Court. Whatever they are giving the judgment, it is the law of the land. So they will comes under the state. It is the common doubt with comes arise with between our students. So it says in Naresh is the state of Maharashtra, judicial functions not within this definition of state. So we can classify judiciary into the two ways. One is judicial function, non-judicial function. What is non-judicial function? Article 145 and 146 of Indian Constitution says the Supreme Court is empowered to make rule for regulating the practice and procedure of court. This is non-judicial function. And then Supreme Court is empowered to make appointment of its staff and servants, decide its service conditions, and then they can decide its service condition also. It is also a non-judicial function. So when it is come to the judicial function, when it is a justice delivery system, that part of judiciary will not comes under Article 12. But if it is a non-judicial function like Article 145 and 146, it is absolutely comes under definition of state. It has been decided in that A.R. Antule versus R.S. Naik also. In this given time, I couldn't make justice to cover all the aspects of this Article 12, but still I tried my level best to touch upon all the corners of Article 12, and then I think I made you think over it, think over the topic, and then I'm very happy to be part of this online refresher course on law conducted by UGC HRDC, Gujarat University, Ahmedabad. I thank you once again. Thank you.